The letter arrived on a Wednesday, I remember, because Wednesdays were my slow days at the shop. The kind of afternoon where I'd sit in the back office with cold coffee and a stack of invoices I kept meaning to file. The mail carrier knocked instead of just dropping it through the slot, which should have been my first sign that something was different about that particular envelope. "Sign here," he said, holding out a clipboard. "Certified mail. Return address from a law firm in Seattle, Kessler and Brown, LLC." I didn't recognize the name. I signed, closed the door, and stood in my own hallway for a long moment just staring at it. I'm not sure why I didn't open it right away. Some instinct, maybe. The same one that makes you slow down before a curve you can't see around. I set it on the kitchen counter and went back to my invoices. My name is not important. What matters is that I was 51 years old, owned a small auto restoration shop outside of Spokane, and had been divorced for 3 years from a woman I'll call my wife, because that's what she was for 11 years. And that's how I still think of her when I'm being generous. When I'm not being generous, I think of her by other names, but I'm trying to keep this civil. We had no kids together. That was a wound of its own, but not the one this story is about. The divorce was her idea, not the cheating. That was mutual, meaning she did it and I found out. She came home one night smelling like someone else's cologne, and when I asked her directly, looking her in the eye the way you do when you already know the answer and you're just giving the other person a chance to be honest, she shrugged. Actually shrugged, like I'd asked her what she wanted for dinner. "I've been seeing someone," she said. I didn't plan it. I asked how long. "About 14 months. 14 months. Our marriage was 11 years old and she'd been seeing someone for 14 months and I hadn't known. I replayed the last year and a half in my head. The weekends, she said she was visiting her sister in Portland. The Tuesday evenings, she stayed late at her book club. The way she'd started sleeping with her back to me, a wall of silence in the dark. I'd noticed all of it. I told myself I was being paranoid. "Who is he?" I asked. She said his name was Philip. He was an architect. He was 44. She said it the way someone reads off a grocery list. I told her to get out of my house. She said it was her house, too. She was right about that. We bought it together in 2014. A craftsman bungalow with a leaking basement and good bones that we'd spent 4 years fixing up. I'd refinished every inch of those hardwood floors by hand. I told her I'd buy her out of her half. She said she'd think about it. She moved into Philip, the architect's condo downtown the following week, with 2 suitcases and my cast iron skillet, which I'm still angry about. The divorce was straightforward enough. No kids, limited shared debt. She got her half of the house's equity. I kept the shop. We split the retirement accounts. My lawyer at the time was a woman named Doris who wore silk scarves and had the calm, efficient energy of someone who had seen every version of marital collapse imaginable. She handled everything cleanly. It was over in 8 months, and that was that. I thought. 3 years passed. I rebuilt. I threw myself into the shop, took on a 67 Chevelle that needed a full frame-off restoration, and let it eat up every hour I had to spare. I started running again, the way I had in my 30s before the marriage made me slow and comfortable. I lost 20 pounds. I started sleeping through the night. I did not think about my wife very much, and when I did, it was with the dull ache of something healed over rather than the sharp pain of something fresh. Then the letter. I finally opened it that evening after dinner, stood at the kitchen counter with a glass of bourbon I hadn't touched, and read it twice. The firm of Kessler and Brown, LLC, was writing on behalf of my ex-wife and one Philip Darren Aldrich, Philip the architect, apparently with a last name, to inform me that their clients intended to file a petition in King County Superior Court challenging my legal capacity to manage a recent financial inheritance, on the grounds that I was exhibiting signs of cognitive decline and was therefore vulnerable to undue influence. I put the letter down. I picked it up and read it again. Cognitive decline. Undue influence. I was 51 years old. I ran a half marathon last spring. I could rebuild a carburetor blindfolded and quote you the specifications of any American muscle car made between 1964 and 1972. I did the New York Times crossword in pen on Sunday mornings because I liked the commitment. And they were claiming I was mentally incompetent. I should back up, because none of this makes sense without the inheritance. My Uncle Howard died in February. We weren't close in the way that people mean when they say they're close. We didn't call each other regularly, didn't spend holidays together, but he was my father's only brother. A quiet man who'd spent 40 years working in commercial real estate in the Pacific Northwest, never married, never spent money on anything except good hiking boots and the occasional fishing trip to Alaska. I knew him the way you know someone you see twice a year at family gatherings. Reliably, warmly, without depth. What I did not know was that Howard had been quietly accumulating wealth for 4 decades while living in a one-bedroom apartment in Tacoma and driving a 2003 Honda Accord. When his estate attorney contacted me in March, I thought there had been a mistake. Your uncle named you sole beneficiary, the attorney told me over the phone. I asked how much we were talking about. He told me. I sat down on the floor of my shop, right there between the Chevelle and a customer's vintage Mustang, and I sat on the concrete floor in my work clothes and stared at the wall for a while. Howard had left me $4.7 million. I hadn't told anyone. That was the first thing the estate attorney advised. Be quiet about it, at least until the estate cleared probate, at least until the funds transferred, at least until you've spoken to a financial advisor. I had a small circle of friends, men I'd known since high school, guys from the shop, nobody I'd have told anyway. I was private by nature. I paid my taxes. I kept my books clean. I didn't talk about money. So how did my ex-wife know? That question didn't occur to me until I was sitting at my kitchen table at midnight with the Kessler and Braun letters spread out in front of me and my phone in my hand, Googling whether an ex-wife had any legal right to challenge an inheritance received 3 years post-divorce. The short answer, which I found in about 4 minutes, was no. Essentially none. The longer answer, which I found over the next 48 hours of reading case law and calling Doris, my divorce attorney, who now charged $400 an hour and was worth every cent, was they had no standing. They knew they had no standing, and the petition would almost certainly be dismissed before it reached a hearing. But they could still file it. And fighting it, even winning, would cost me time and money and the particular misery of having my personal life scrutinized by a court. It's harassment, Doris said, matter-of-factly. It's a nuisance filing. They're hoping you'll offer a settlement to make it go away. Settlement, I repeated. That's the game. I asked her who I should call. She gave me the name of an attorney named Garrett, not the divorce kind, the estate and asset protection kind. She said he was aggressive and detail-oriented and that opposing counsel tended to find him unpleasant, which she said with a small amount of professional satisfaction. I called him the next morning. His name was Garrett Finch. He was in his mid-40s, had an office in downtown Spokane with floor-to-ceiling bookshelves and a leather chair that had seen better decades. He read through the Kessler and Braun letter while I sat across from him, and when he finished, he set it on the desk and looked at me with the expression of a man who found this particular situation genuinely interesting. They're claiming you're exhibiting signs of cognitive decline, he said. I know. What evidence do they have? None that I'm aware of. Do you have a doctor? Regular checkups? Annual physical every October? Clean bill of health? He nodded slowly. Are there any witnesses who could corroborate unusual behavior? Anything you've done recently that could be framed as erratic financial decision-making? I thought about it. I'd bought a new bandsaw for the shop in April. I'd contributed to my Roth IRA. I'd replaced the gutters on the house. I bought a bandsaw, I said. He almost smiled. We'll keep that in reserve. He leaned back. Here's what I need you to understand. They can file this petition. The court will require a response. We will file that response, and it will be thorough, and it will include documentation of your medical history, your financial history, your business records, and any relevant testimony. And when it's dismissed, which it will be, we explore whether grounds exist for a sanctions motion and potentially a claim for abuse of process. Can we win that? Depends on how egregious the filing is. Filing a petition you know has no legal basis in order to coerce a financial settlement is potentially sanctionable. He paused. There's something else I want you to think about. How did she know about the inheritance? There it was. The question I'd been circling for 2 days. Howard's estate had been handled by an attorney in Tacoma. The probate filing was public record once submitted. Anyone could theoretically access it. But the filing had only gone in 6 weeks ago. Either someone was watching the probate docket specifically for my name, which was unlikely, or someone had told her. I thought about who knew. The estate attorney. My financial advisor. Doris. And then I thought about something else. My ex-wife had a cousin who worked as a paralegal at a firm in Tacoma. I'd met her twice at family events during the marriage. A sharp-eyed woman named Patricia, who'd always struck me as someone who paid close attention to things that weren't her business. Tacoma was not a large legal community. I mentioned this to Garrett. He wrote it down without comment. The petition was filed on a Thursday. I know this because Garrett called me that afternoon while I was under a car, and I had to slide out on a creeper and take the call in the parking lot with grease on my hands, which felt appropriate somehow. Me with dirty hands doing real work, and them across the state filing papers that were fundamentally fraudulent. It's filed, Garrett said. Exactly what we expected. They've attached a declaration from your ex-wife stating that you contacted her in a confused state after learning about the inheritance, that you were disoriented and making statements that concerned her. I stood very still in the parking lot. I have not spoken to my ex-wife, I said, in 2 years and 4 months. I know, Garrett said. Do you have phone records? I have everything. Good. I need them. Here's the thing about being someone who grew up without much money. The kind of kid who knows that things can disappear quickly and without warning. You keep records. My father taught me that. Keep your receipts, keep your contracts, document everything. Because a handshake isn't worth anything when someone decides to change their story. I had phone records going back 4 years. I had email archives. I had a habit of confirming things in writing that my ex-wife had always found mildly irritating. That habit was about to be very useful. I sent Garrett everything that afternoon. Every phone log. Every email. A complete record of every communication I'd had with my ex-wife since the divorce was finalized, which amounted to 2 brief text exchanges about the final disposition of some shared furniture in early 2022, and nothing after. He reviewed it overnight and called me the next morning. The declaration is false, he said, simply, cleanly. She claims you called her on March 14th of this year in a confused and distressed state. Your phone records show no outgoing call to her number on that date or any date within the last 2.5 years. So she lied to the court. Under penalty of perjury, yes. That's significant. I felt something settle in my chest. Not satisfaction exactly, more like the feeling of solid ground after a long time on uncertain footing. Garrett filed our response 2 weeks later. I read it before it went in, all 43 pages of it. It was, in the most technical legal sense, a demolition. It laid out the absence of any relationship between an ex-spouse and an inheritance received post-divorce. It documented the complete lack of grounds for a cognitive competency challenge. It included letters from my physician, my accountant, my shop's CPA, and 3 character declarations from people who worked with me regularly. It pointed out with surgical precision the false statement in the petitioner's declaration, supported by phone records, and requested the court take notice of the discrepancy. And at the end, it included a motion for sanctions. My ex-wife's attorney, a man named Kessler, the first of the 2 names on the firm's letterhead, filed a response to our response that managed to be both aggressive and hollow. He argued that my ex-wife had genuine concerns for my well-being. He said the phone call discrepancy was a matter of potential confusion over dates. He said his clients were acting in good faith. Garrett read it and sent me a 1-line email. They're scared. The hearing was scheduled for a Tuesday morning in October. I drove to Seattle the night before and stayed in a hotel downtown, the kind of place with thick curtains and white noise from the street that I usually find comforting. I lay in the dark for a long time thinking about 11 years of marriage and how it ends up in a courtroom over money that neither of them had any claim to. I thought about Philip the architect, who had apparently decided that my ex-wife's theoretical access to my dead uncle's money was worth becoming involved in a court proceeding over. I thought about what kind of person makes that calculation. I thought about my Uncle Howard, who spent 40 years quietly building something in a 1-bedroom apartment, driving a sensible car, asking nothing of anyone, and then left it all to a nephew he saw twice a year at family gatherings. I hoped he'd known I would fight for it. The hearing lasted less than an hour. I don't want to make it sound more dramatic than it was. Courtrooms are not like television. There's a lot of waiting in hard chairs and shuffling of documents and speaking in careful, measured sentences. The judge was a woman in her early 60s who had clearly read every filing and had questions ready. She asked Kessler to explain the legal basis for his client's standing to challenge the competency of a former spouse, divorced 3 years prior, with no shared financial interests and no ongoing legal relationship. Kessler talked for about 4 minutes. He used the words good faith concern twice and humanitarian basis once. The judge wrote something on a notepad. She asked him to address the discrepancy in the declaration, specifically, the claim of a phone call that phone records showed had not occurred. Kessler said there may have been confusion about dates, that his client believed the contact had occurred, that memory was imperfect. The judge looked at him for a moment without expression. She did not grant the petition. She dismissed it, without prejudice on the cognitive standing question, meaning they couldn't refile it, and took Garrett's sanctions motion under advisement. Then she said something I've thought about many times since. She said, the court takes seriously the integrity of declarations submitted under penalty of perjury. Parties and their counsel are reminded that filing petitions for improper purposes has consequences. Kessler went very still. My ex-wife, sitting 2 rows ahead of me in the gallery, did not turn around. I drove back to Spokane that evening. I stopped at a diner outside of Ellensburg and ate eggs and toast and drank bad coffee and watched the sun go down over the eastern Washington hills, which are brown and rolling and beautiful in a way that people who haven't been there don't expect. Garrett called me 3 weeks later. The court had granted the sanctions motion. Kessler and Brown and their clients were ordered to pay a portion of my legal fees and were formally censured for the frivolous filing. Garrett told me the amount with a quiet satisfaction in his voice. It wasn't everything I'd spent, but it was enough. There was more. The Bar Association had received a complaint. Garrett filed it himself, separately, regarding the false declaration. An inquiry was opened into Kessler's conduct. I don't know what came of it ultimately, because Garrett told me these things take time and outcomes are never guaranteed, and I decided somewhere around that point that I needed to stop waiting for the next piece of news and start living the life that Howard's money was supposed to make possible. What I do know is that Philip the architect quietly ended his relationship with my ex-wife approximately 2 months after the dismissal. I know this not because I was keeping track of her life, but because a mutual friend mentioned it once, in passing, without knowing I'd care. And I found, to my mild surprise, that I didn't. Not really. It was information that landed and then settled, like something that happened to someone I used to know. The cousin who worked as a paralegal in Tacoma, the one I suspected had tipped off my ex-wife about the probate filing. She's a separate matter entirely. Garrett looked into it. What he found was enough to indicate that she had, in fact, accessed information about my estate through her firm's record system, which raised questions about client confidentiality and professional conduct that were referred to the appropriate people. I'm told an internal review was conducted. Beyond that, I don't have details and I've stopped pursuing them. Some things you have to let be. The shop is doing well. I hired a second mechanic last spring, a kid named, well, that doesn't matter. He's good with his hands and shows up on time, which covers most of what I need. We finished the Chevelle in February, and the owner cried when he saw it, a big guy in his 60s who'd bought the car as a wreck because it had been his father's, and he stood in the parking lot with his hand on the hood and his eyes wet and said, "It looks like it did when I was 12 years old." That's the work I care about. Howard's money sits in a trust now, managed by a financial advisor Garrett recommended, a careful woman who sends me quarterly reports I read twice and then file in a cabinet. I bought new equipment for the shop. I paid off the house. The rest is growing slowly the way my uncle grew it. Quietly, without drama, without anyone needing to know. I am 52 now. I run 3 times a week. I do the crossword and pen on Sunday mornings. Last month I drove up to the Canadian Rockies alone and hiked for 4 days and didn't talk to anyone except one other hiker I passed on a trail who nodded and kept going, which was exactly the right amount of human contact for that particular stretch of time. I thought about Howard up there in the mountains. Thought about the kind of life you build in silence and what it means when you leave it to someone. I hope I'm living up to it. I think I'm trying to. The letter arrived on a Wednesday, and for a while it threatened to undo everything I'd spent 3 years building back up. But the thing about building something yourself, brick by brick, board by board, is that you know exactly what it's made of. You know where the weight is. You know which pieces you can trust. When someone comes to take it from you, you're not helpless. You're just someone who knows their own house. And they didn't know that about me. That was their first mistake, and as it turned out, it was their only one. I spent a lot of time since then thinking about what actually happened. Not the legal mechanics of it, not the filings and the hearings and the sanctions order, but the thing underneath all of it. The reason any of it was possible. My ex-wife and Philip looked at my life and saw a target. They saw a quiet man in a small city who fixed old cars and kept to himself. And they decided that quietness was the same as weakness. That privacy was the same as vulnerability. That because I hadn't made a show of what I had or what I knew, I wouldn't know how to fight for it. That's the calculation people make when they've spent their lives using loudness as a substitute for substance. They mistake silence for emptiness. What they didn't account for was that I'd spent 30 years building things. Not just the shop, not just the house, myself. The habit of documenting everything came from my father, who grew up without money and knew that the world doesn't give you the benefit of the doubt when you can't prove what you're owed. The habit of staying calm under pressure came from years of working with my hands, where panic makes you sloppy and sloppiness gets people hurt. The discipline to keep records, maintain relationships, pay attention. None of that happened by accident. It was built the same way you build anything worth keeping. Slowly, without fanfare. One decision at a time. That's the part nobody talks about when they tell stories like this one. They talk about the villain's downfall, the courtroom moment, the sanctions order, and those things matter. But what made those things possible wasn't luck, and it wasn't the inheritance itself. It was 30 years of living with enough integrity that when someone tried to claim I was mentally unfit, my own life stood up and called them a liar. Garrett didn't win that case. My phone records did. My medical history did. My accountant's records did. The declarations from people who'd known me for 20 years and were willing to put their names on paper did. I just had the good sense to keep all of it. I think about Howard a lot these days. A man who built $4.7 million in absolute quiet, who asked nothing of anyone, who trusted me with everything he'd made. I don't think he chose me because I was the most successful person in our family, or the most impressive. I think he chose me because he recognized something. The same orientation toward work and honesty and keeping your head down that he'd spent his whole life practicing. He saw it the way quiet people see each other across a room. I'm trying to be worth that trust. Some days I think I'm doing all right. What I know for certain is this. The people who came after what Howard left me didn't fail because of bad luck or bad timing. They failed because everything they'd built was hollow. A false declaration. A petition with no legal foundation. A relationship of convenience dressed up as concern. When Garrett put pressure on any of it, it collapsed immediately because there was nothing underneath. You can't fake your way to solid ground. It doesn't matter how good the paperwork looks or how confident the attorney sounds. Eventually, something real is required. And if you don't have it, the whole thing comes apart. I'm 52 years old. I have a shop I'm proud of, a house I built with my own hands, and a trust account I didn't ask for, that I'm trying to steward carefully. I have a mechanic who shows up on time and a Sunday crossword habit and the memory of 4 days alone in the Canadian Rockies, where I felt, for the first time in a long time, completely like myself. That's what they were really after. Not the money. The money was just the number they put on it. What they wanted was to take something that wasn't theirs. And the only reason they failed is because I'd spent a lifetime making sure the things I had were genuinely mine, built by hand, documented in full, and not for sale at any price.